Hi, I'm Brian Heidelberger. I'm partner with the law firm of Winston Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, a cautionary tale for advertising agencies in billing disputes with clients. But first, you see, we got some new digs here at the mini law lessons. I hope you like it. But what happened today? Well, Patron spirits in a lawsuit with Reindeer Group, which is a digital marketing agency. It looks like they had a nice relationship, and Reindeer probably did some good work. But when Patron elected to terminate the relationship, things got ugly. Now, there was an agency-client agreement between the parties, and Patron alleges that Reindeer was responsible for providing supporting documentation for all purchases, that any intellectual property that was created under the relationship was owned by Patron at the termination of the relationship, and that Reindeer would not display any intellectual property of Patron without Patron's prior express written permission. Well, when the termination happened, Reindeer put forth some bills. Patron disputed those bills and asked for supporting documentation. Now, they allege that Reindeer did not submit sufficient supporting documentation to pay those bills. Patron rejected those bills. They also asked for the transfer of a domain name that was created in conjunction with the work, Patron Cocktail Labs, which was registered by Reindeer. Reindeer refused to turn that intellectual property over to Patron, obviously because it expected to get paid more money before it would. And also, Reindeer had on their website some examples of its work for Patron, and including a statement that it was a current agency for Patron. And when Patron asked them to take that down, Reindeer went dark as well, didn't respond, didn't take it down. So what did Patron do? Well, they filed a lawsuit. They filed a lawsuit, one, asking for their domain name back under anti-cyber squatting laws. Two, they demanded the takedown of the statement on Reindeer's website, as well as alleged trademark infringement for the use by Reindeer on its website, stating that it was a current agency of Patron when in fact it allegedly was not. And then they also are asking for the court to declare that Patron does not owe the monies that are being demanded by Reindeer. So we'll keep you updated on this case, but you don't see a lot of billing disputes play out in court, so I thought it would be an interesting one for all you agency people, for CFOs, even for the brand people to see how these things happen. So as I mentioned, it's a little bit of a cautionary tale. What happened here? Reindeer got in this dispute, and now they're going to have an expensive lawsuit. It might have been better to sit back and turn the materials over to Patron, take the stuff down from the website, and work it out instead of forcing their hand. So I hope this one was helpful. We'll see you next time. Until then, let's be careful out there.